Hello, and welcome to the latest podcast in the Bindmans Immigration Unpacked series. My name is Tanya Goldfarb, and I'm Head of Business Immigration at Bindmans. I'm joined by my wonderful colleague, Natalie Loader, who is a partner in the immigration team, also at Bindmans. Today, we are looking to explore the tantalizing world of right-to-work checks, and in particular, the recent Home Office self-reversal on a particularly vexing aspect of the right-to-work check regime. So, let's set the scene. On the 5th and 6th of March of this year, changes to Parts 2 and a number of other parts of the Workers and Temporary Workers Guidance set of documents were extended by the Home Office and updated and expanded. In particular, they extended the obligation by sponsor license holders to conduct right-to-work checks on, and I quote, any worker you wish to employ or sponsor, including a worker who is not your direct employee. A somewhat cautious reading of the guidance, of this new guidance, implied that the duty of sponsors to conduct right-to-work checks extended to employees and sponsored individuals, even where the sponsored individual was not an employee. This obviously and unfortunately caused much confusion and appeared to contradict other elements of sponsor guidance and also parts of the Right to Work Code of Practice and Guidance. And so, in an interesting self-reversal, on the 20th of May, the Home Office published further updates to the sponsor guidance concerning that said Right to Work check regime. I think it's fair to say that these changes help to restore some clarity and are endeavouring to simplify sponsor compliance by reversing the expanded duties which were introduced in March and then also further changes in April. And I also believe that it has brought some relief to a much expanded obligation that resulted from the March updates. So in this podcast, I'm discussing with Natalie the recent, what we could possibly call a little bit of a flip-flop, and we look ahead to what might be on the horizon for right-to-work checks. So Natalie, could you just gently walk us through how the guidance changed in March and latterly in April, and then and tell us why this caused so much sort of consternation and confusion amongst sponsors?
Thanks, Tanya. Yes, so on the 6th of March, there was an amendment to Part 2 of the Worker and Temporary Worker Guidance, and it said that sponsors must, as an obligation, conduct right-to-work checks on any worker you wish to employ or sponsor, including a worker who is not your direct employee. Then, an amendment was made to the same guidance on the 8th of April, which also affirmed that there was an extension on the duty of sponsors to conduct right-to-work checks on their own employees and anyone that they engage directly. And I think this is the big problem, that there was no definition of what they mean by engage directly. Also on the 8th of April amendment, the guidance was changed to say that if right-to-work checks are not carried out, a sponsor would be in breach of its duties. The guidance made it clear that sponsors may be liable for civil penalty or even have their licenses revoked if they don't do the right-to-work checks properly. So I think the confusion is, what do the Home Office mean by engage and what do they mean by direct engagely? It wasn't defined anywhere in the guidance. And so just on a lack of any sort of clear definition in the guidance, then it wasn't unreasonable for people to assume that this meant that sponsors have to extend their right to work checks to include any self-employed individuals carrying out work directly for them, whether they're sponsored or not, independent contractors carrying out work for them, consultants carrying out work for them, workers who are contracted by them to carry out work for them, employees, and then anyone else they sponsor regardless of their status. So this uncertainty and confusion led to what seemed like a very widened scope of the right to work regime. And then, of course, this is all against the background because in those same changes, the Home Office was reaffirming, we've mentioned it before in previous podcasts, Tanya, the Home Office was reaffirming that participation in the sponsorship scheme is voluntary and sponsors seek membership at their own benefit. Members are subject to strict terms which are contained in the guidance, and sponsors have to be aware that a license is held at the broad discretion of the Home Office and can be terminated at any time, and a license creates no property or other enforceable rights. So you're volunteering to be in this system. You just have to comply with whatever the guidance says, however however it is interpreted. Then thankfully on the 20th of May, there was an amendment. And what the Home Office said in relation to this amendment when they published the guidance was that amendments have been made to the published guidance on the 6th of March and the 8th of April, because it suggested that sponsors were required to undertake right to work checks on unsponsored workers directly engaged but not employed by them. Following user feedback, this reference has now been deleted, and any reference in those versions to unsponsored workers engaged or directly engaged by the sponsor should be disregarded. So we don't need to worry about those changes on the 6th of March and the 8th of April. We've reverted back to where we were before. So this means that the update on the 20th of May says that sponsors must carry out right to work checks for any worker being sponsored, and that's still whether they're directly employed by them or not. Because remember, there are some instances where you might be sponsoring someone, but they're not necessarily your direct employee. In most cases, we would assume they are, right? But for instance, a partner in an LLP can be sponsored by
Right.
the LLP, but technically they're self-employed. They're not an employee. So any worker being sponsored, so anyone that you issue a certificate of sponsorship for and you are sponsoring them, you must do a right to work check for that person. And then any employee of the sponsor, so this is regardless of being sponsored or not, so you must conduct checks on
Right.
your whole population, your employee population. And this is because you must make sure you're not employing somebody illegally. So just because they don't need sponsorship, it doesn't mean that their visa allows them to work. Well, just because they don't have sponsorship, it doesn't mean that their visa allows them to work. So you must check everyone, even if you think they're British, even if you think they're Irish, even if you think they've got settled status and have permission to work. How do you know that if you don't conduct the check? How do you prove to the Home Office that you don't know that if you don't conduct a check? So you must do the check. And then
And
part,
sorry if I may
yes.
interject just
Mm.
very briefly. And it should also be noted that you must conduct the right to work check in accordance with the right to work code of practice and the
That's right.
established systems that are the established processes that are in place.
That's right. That's right. So that means you must do the right to work check on or before someone starts work. So the day on or before the day they start work. If it's on the day they start work, you're really leaving it very late. You must do that check before they're permitted to go to their desk, before they're permitted to have any induction training, before they're permitted to do anything which could be construed as work for the business. So you would have to intercept them at reception as soon as they arrive to do that right to work check. It's
Yeah.
so much better to do it before the start date, because if there are any issues with the right to work, you don't have a line manager who's expecting to have someone join their team, but then can't join the team because you've realised there's an issue with right to work, and potentially sponsorship may be required or further checks are required. So really try to do it before someone joins the business. And then if someone's visa is on a visa, whether it's sponsored or not, you must do a right to work check before that visa expires. Then you must get evidence that they've submitted their application in time, and do another right to work check if you get to the end date of the visa and they don't have a visa for sponsorship. So if they've got an e-visa, the e-visa should say they've got pending application and they're allowed to work until there's a decision on it. In some cases, you might still need to do an ECS check, an employer check and service request. And then when they get their new visa, you must check that visa again. So there's a
Indeed.
lot of checking around when someone's visa is going to expire. And some businesses will take a belts and braces approach, and they will do annual checks on right to work. And we really recommend this as well, because it's a way of just keep making sure that someone isn't expiring without your knowledge, or they haven't changed their visa, but they haven't told you. If you're doing annual right to work checks on anyone with the visa, then you're catching these issues, hopefully, before they become an issue. But you should also be reminding your employee population that it is on them to tell you if their visa status changes or if they change their visa. That's basically the changes. So a change and then a flip back to where we were before, and then just a reminder of what you need to do in terms of your right to work checks.
Brilliant. Thank you. And so why do you think that the Home Office so very quickly reversed itself in terms of
Mm,
expansion and then a
sure,
retraction of the regime?
sure. I think, there needs to be a lead time. So what we're potentially looking at, it's more grave than you think. So there are proposed changes to the illegal working regime, and they are coming into force with the Border Security, Asylum and Immigration Act 2025, which has received royal assent. It hasn't come in yet. So these changes, in a way, just preempted what's down the line. But because the changes are going to represent a very expanded right to work checking regime, businesses will need some time to put processes in place to make sure they're going to be able to meet these requirements. Because we have to remember as well, if you aren't meeting the requirements of your right to work check, regardless of whether or not illegal working has taken place. So this is the important thing. So you must do the right to work check in line with the guidance on right to work checking. You can have your license suspended or revoked if you aren't doing the checks. If you get a civil penalty because you do have an illegal worker, then that's pretty much game over for your license. It's very likely to be
It
revoked, isn't
is.
it? But you
Yes.
can still be penalised even if there hasn't been any illegal working, but you haven't met your sponsorship duty of doing the right to work checks in line with the guidance. So if they were going to expand the regime so massively, they can't really do that without giving prior notice because businesses are going to need time to put processes in place. So I think there was feedback from lawyers, from sponsors, and other stakeholders to revert back to the prior position and removing the phrase, that you must conduct the check on a worker. On any worker you wish to employ or engage directly, because it just wasn't manageable at such short notice.
Absolutely. And I think it's also fair to say and to reiterate that the right to work check regime is a necessary obligation for all employers in the UK, not just those that hold a sponsor license. So
Mm,
when you and I are talking about the sponsor obligation,
mm,
that is a specific obligation because you have, or as an entity, an organization, a business has been assigned or issued a sponsor license to enable
mhm.
it to assign certificates of sponsorship.
Yeah.
However, the right to work regime applies to all employers in the UK, regardless of whether you hold a sponsor license. So it is confusing, and there are
Hmm.
specific additional sponsor obligations that make holding a sponsor license be reinforced by the
Hmm.
unfortunate mantra that the Home Office like to repeat throughout the guidance, which is that sponsorship is a privilege, not a
Hmm.
right. And,
That's
and that
right.
applies both to individuals being sponsored and to sponsors who are assigning certificates and operating a sponsor license.
Yes,
Um,
exactly.
do you think that we're likely to see any other changes? Have the government announced any other proposals or updates to right to work check on the horizon?
So I think these are the changes that are contained in the Border Securities, Asylum and Immigration Act. So there was a public consultation which ended on the 29th of April, 2026, and I hope everyone fed into it. And so I think that the Home Office is saying that the new code of practice for right to work checking could come in as early as the 1st of October 2026. So it's actually not that far down the track if that's really going to happen. Who knows? Sometimes we get these dates and nothing happens by that date. I mean, we've got a lot of other changes to immigration which are sort of pending for autumn as
Yes,
well. So we don't
yes,
know
we
whether
do.
this will come in or not. But if these changes come in, then there is an expanded definition of those who you need to conduct right to work checks for. So it will include anyone who is under a contract of employment or a contract of service or an apprenticeship, anyone who's under a worker contract, any individual who's a subcontractor, and then also anyone who has come to the business through an online matching service, where you use an online service to match workers with sponsors or with employers. So it's it's really very broad, and this could mean that the business may or may not have a contractual relationship with the individual, but they still need to do the right to work check. And it could even be that they don't even really know the individual providing the work or services, but they still need to do that right to work
Right.
check. So it's really going to be quite tricky. And I would say that what we would expect sponsors to be doing, or any business, so it doesn't just impact sponsors, it impacts all businesses, all employers. But we specifically concentrate on those who hold sponsor licenses because we want to help them make sure that they're going to be meeting their sponsor obligations so that they can retain their sponsor licenses, which are, important for their business, so they can sponsor workers in the UK for employment. So we would say review your existing right to work checking processes, review your record keeping systems, do this routinely, make sure they're working, make sure you're capturing everyone in order to minimize your exposure to illegal working or civil penalties or other sanctions. Get your immigration lawyer to come in and do an audit of your systems if you're not sure whether you're complying. So what Tanya and I often see is that you have businesses that think they're complying with the rules, but actually when you look into it, there are a few areas where they're falling down. But otherwise they're doing everything which they believe is in accordance with the guidance. But there just are a lot of obligations on sponsors, and where you
Yes.
do have a set pattern and you think you're doing everything correctly, if you are falling down on one issue, that then just perpetuates, and so one mistake could become two, could become three, could become four, and then that just compounds itself. So get your immigration lawyers to come in and help you, get them to do an audit, get them to do a review of your right to work checking process, make sure that everything is tip top, and that if the Home Office come in to do their audit, they're going to be happy with what they find, and they're going to say, yes, this sponsor is meeting all of their obligations under our voluntary scheme. Um, and also, you might want to consider now beginning to widen the scope of who you're doing your right to work checks for, in anticipation that these changes are
Definitely.
coming in. Even if they don't come in on the 1st of October, they're on the horizon and they're going to come in. So you want to be reviewing what it is that you will need to do to expand your right to work checking process to ensure it picks up everyone it needs to pick up. And maybe, as part of this, you're going to need to do an impact assessment on how it's going to impact the business, because you may need additional resources, because it could be that, if you have a high turnover of people, if you have lots of people joining all of the time, if you're using lots of contractors or subcontractors, perhaps you need to have additional resources and budget to help you comply with these changes. You might want to consider using an identity service provider. So this is called an IDSP, and that's where you sort of have a digital check on holders of British and Irish passports, but it's done through a third party. You do have to pay a fee for each one you do through an IDSP, so it might not be relevant for everybody, but that's one way you can sort of reduce the burden on your human resources staff.
Sorry to interject, although
Yes,
do note that even when you do use an
yes,
IDSP, you cannot solely rely on it to
that's
establish a
right.
statutory defence. So
That's
you have
right.
to check the check that they have undertaken on your behalf.
Yes, that's right. So Tanya's talking about a statutory excuse against a fine for illegal working. So if it does turn out, for instance, that someone who presents themselves with a British passport, and it turns out that British passport is fake, it's not a real British passport, then if you have used an IDSP, it doesn't give you a statutory excuse against a fine, because you haven't established that excuse against a fine because you didn't conduct the check yourself. So there are issues around IDSPs. I mean, the Home Office say you can use them, but it doesn't actually get you exactly to where you need to be in terms of satisfying or in terms of having the protection you need in case someone is an illegal worker.
Which is
Um,
most unfortunate.
yeah. And the other thing is stay on top of the guidance. There's an express duty that sponsors must read the guidance and they must know what is contained in the guidance. It is no longer an excuse to say, oh, we didn't know about that change. We had no
No.
idea. The Home Office is saying you've signed up to the voluntary system. You've come to us saying, I want to be part of your sponsorship membership club. So we expect that you keep up to date with our rules, and our rules say you have to read the guidance. So make sure you have a level 1 user logging into the sponsor management system at least once a month. Check the notice board. The Home Office will put up notifications there if they have changed anything in the guidance. But also make sure you are checking the actual guidance itself. The guidance, when you click into it, will tell you when the latest update was, so you'll know whether or not there's been an update since you last looked at it. If there are changes, identify what they are and circulate them to the relevant stakeholders within your business who need to know what these changes are. If you're unsure about anything, contact your immigration lawyer.
Absolutely. And it's important to note also that the Home Office do track when people are logging into the SMS, and they
Mhm.
do notice if there's been no engagement, there's been no checking of the message board, there haven't been sponsor notes made as needed. And so it is really important. I would absolutely reinforce Natalie's point about engaging with your sponsor license, engaging with by interfacing through the SMS system. I think a couple of other points that should also be noticed in terms of the draft new code is that there are proposed changes also to the definition of
Oh,
worker,
yes.
meaning an individual employed by an employer in any of the working arrangements within the scope of the employer definition. Right to work means being allowed to engage in work by virtue of holding what the wording calls a qualifying immigration status,
Mhm.
and also, interestingly, a revised definition of an e-visa. Currently, the definition is that it's a digital visa provided by the Home Office as evidence of a person's immigration status. In other words, permission to stay or enter the
Mm.
UK. Two, and the new definition is proposed to be an online record provided by the Home Office of a person's immigration status and the conditions of their permission to stay or enter in the UK. So it's moved from being the underlying visa to a record of the permission granted. So it's slightly morphed from being a more substantive status reading to a sort of a display or a record, which is
Mm.
I wonder whether that will end up being revised further
Mm.
following representations being made to the Home Office. And interestingly enough, also permission to stay, which is currently defined as a person has permission from the Home Office to be in the UK, to permission from the Home Office to remain in the UK for a specified period. So
Mm.
we're seeing a sort of a slightly compliance-led language change in
Yeah.
terms of the definitions of legal terms within the immigration lexicon, really. I think that that's a good place for us to wrap up, unless you have any other top tips for sponsors and employers out there, Natalie. And I
I
don't mean
think
to put
just
you on the spot
yes,
at
no,
all. I
just
apologize.
stay
Stay
plugged in.
vigilant.
Yes, exactly. Read the guidance, make sure you're logging into the SMS. Really, now is not the time to snooze. We say this all the time, Tanya. I'm saying it again. There are lots of changes in sponsor compliance. The Home Office are cranking up their checks. They can do a lot of checks remotely without you even knowing that they're checking you. They can see when you've done a right to work check. They can see through HMRC records when someone commenced work. They can see when you've conducted the check too late. It's after the start date declared to HMRC. And, if they see lots of instances of this, very likely they're going to investigate your license. And then, you could be facing a suspension or revocation if you haven't properly met these rules. And at that point, it may be too late. Where they're pointing out mistakes to you, it's probably too late at that point to say, we've rectified it. Please, we hold our hands up. That was a mistake. We've rectified it. Previously, if you rectified something and it was robust enough, then the Home Office would give you the benefit of the doubt. We're seeing less of that now. It's not completely, out of the question that they would say, okay, we will give you another chance. But we are seeing a much harder approach, a much stricter approach. So now is the time to make sure all of your processes are meeting your sponsor obligations. Do internal audits. If you're not sure how to go about it, contact your immigration lawyer.
Absolutely. We don't wish to alarm you, but we do wish for you to, as Natalie says, stay on top of things. Do check the guidance, and if in doubt, reach out. And thank you for watching and or listening to this latest edition in our podcast series. Either Natalie or I or other colleagues will be back with another in a couple of weeks. Thank you.
Thank you.